In today's video, I'm going to discuss about another type of law, that is International Humanitarian Law, also known as IHL. By the end of this video, you will get to know what is IHL, its historical evolution, the sources of IHL, followed by the core principles of IHL, which includes distinction, proportionality, precaution, humane treatment, and military necessity. So what is international humanitarian law? These days, we can often hear about this type of law, unfortunately, because of the prevailing armed conflicts in different parts of the world. So international humanitarian law, also known as the law of war, seeks to limit the humanitarian consequences of armed conflicts. The law does not prohibit warfare. In fact, public international law has recognized two concepts or theories known as jus ad bellum and jus in bello. Jus ad bellum refers to the right to war, which means every state party has a right to wage war against an enemy party for self-defense. And also, once a party enters into a war, they are bound by the law of war, which is the international humanitarian law. So the primary purpose of IHL is to restrict the means and methods of warfare. For example, there are conventions which we will discuss later on in the video, which prohibits the use of biological weapons, chemical weapons, and also nuclear weapons. So law does not prohibit warfare, but it does restrict the means and methods that you can use in an armed conflict. Secondly, IHL ensures the protection and humane treatment of persons who are not or no longer taking a direct part in the hostilities. So this includes civilians, prisoners of war, and also wounded and sick soldiers. So the primary purpose of IHL is to protect those who do not take direct part in the hostilities and to restrict the means and methods of warfare. So looking back into the historical evolution of IHL, there is this famous saying that the laws of war are as old as war itself. This in fact is true. If you look into the world history, it is full of armed conflicts. However, these were regulated by certain rules and regulations which were set forth by the kings or the rulers during those times. So one example is the Sumerians, who treated war as a state governed by the law, and it was started by a declaration of war and terminated by a peace treaty. Not just that, if you look at the Code of Hammurabi, you can see that there is a guarantee on the protection of weak from the oppressive hands of the rich and strong, and they have made provisions to release the hostages by ransom. Also, another example is in the 7th century BC, King Cyrus of Persia has ordered that the wounded soldiers of the adversaries should be treated and cared for like their own wounded soldiers. Also, in 400 BCE, the Indian epic Mahabharata mentions that the killing of a surrendered adversary was absolutely prohibited. Going forward to the medieval period, this is when the just war theory emerged. The two principles that we just discussed, jus ad bellum and jus in bello, are part of the just war theory introduced by philosophers like St. Augustine and Thomas Aquinas, who established moral principles for war. When we talk about modern IHL, there is a personality that we cannot forget about, and that is Sir Henry Dunant, who is the founder of the Red Cross movement. He was a businessman traveling to Italy in 1859, where he witnessed the Battle of Solferino, and he experienced the sufferings of the wounded soldiers who were left unattended after the battle. And he wrote the book, A Memory of Solferino, and advocated for organized humanitarian aid during wars. This eventually led to the establishment of the International Committee of the Red Cross in 1863, followed by the adoption of the first Geneva Convention to protect wounded soldiers and medical personnel in 1864. So this can be considered as the first codification of international humanitarian law, which is one of the important points in the history of IHL. Next, let us look at the sources of IHL. We can mainly identify two sources, that is treaty law and customary law. Treaty law is also of two types, Geneva law and Hague law. Geneva law is there to protect and provide humane treatment for persons who are not or no longer taking a direct part in hostilities, whereas Hague law is there to restrict the means and methods of warfare. Moving on to customary law, it is the general state practice accepted as law and it exists alongside treaty law and independently of it. So when we talk about treaty law, Geneva law takes prominence. We have 4 Geneva Conventions which were implemented in 1949 and which are by now ratified by almost all the countries in the world. So these 4 conventions are the first Geneva Convention on the wounded and sick in armed forces in the field, the second Geneva Convention on the wounded, the sick, and the shipwrecked in armed forces at sea, the third Geneva Convention on the prisoners of war, and finally the fourth Geneva Convention on civilians. So in addition to these 4 conventions, in 1977, 2 additional protocols were added for international armed conflicts and non-international armed conflicts. And in 2005, the additional protocol 3 was introduced, which is on the additional distinctive emblem. I will not discuss these conventions and additional protocols in detail here. If you wish to know more about these treaty laws, please comment and let me know so that I can make future videos on these topics. So the next type of treaty law is Hague law. So we can see 2 main conferences were held in Hague, Netherlands in 1899 and 1907. During these 2 conferences, several conventions were passed to restrict the means and methods of warfare. This was followed by several other conventions. In 1954, the Hague Convention for the Protection of Cultural Property was passed, and the Biological Weapons Convention in 1972, and convention prohibiting certain conventional weapons and its protocols were passed in 1980. Also, we can see after 1990s, there were certain treaties which were inspired by the Hague Principles, which includes Chemical Weapons Convention, Ottawa Treaty, or the Prohibition of Anti-Personnel Mines, Cluster Munitions Convention, and the Treaty on the Prohibition of Nuclear Weapons, which was somewhat recently enforced in 2021. So the next type or the next source of law is customary international law. You can also refer to it as customary IHL. This is a body of unwritten rules that exist independent of treaty law, and they govern the conduct of parties during an armed conflict. Even though we refer to it as unwritten rules, today we can find a book which was compiled by the ICRC and published by the Cambridge University Press, which has taken together almost all the state practices and legal opinions that are prevailing at the time on IHL. But it is important to remember that customary international law is a dynamic body of law which constantly evolves in tandem with state practice and legal opinion. So we can, in the future also, we can add more rules and regulations through state practices into customary international law. And one important difference between treaty law and customary law is the fact that state parties are obliged to follow treaty law only if they ratify those treaties into their national law. However, customary law is binding on all parties to an armed conflict, irrespective of their treaty obligations. For example, if a state party has not ratified Hague law on chemical weapons, it still has to follow the customary laws which prohibit the use of weapons that cause superfluous injuries. So, anyway, even if a treaty is not ratified, state parties are bound by the customary laws. Moving on to the core principles of IHL. Here again, I'm not going in depth to discuss about these principles. We have quite a lot to discuss about these principles. So if you want further discussions, please let me know so that I can consider making future videos on these topics. And distinction is one of the main principles of IHL, which requires parties to an armed conflict to distinguish between civilian population and combatants, and also between civilian objects and military objectives. So the second principle is proportionality, which requires parties to an armed conflict to avoid any attack which may be expected to cause incidental loss of civilian life, injury to civilians, and damage to civilian objects, or a combination thereof, which would be excessive in relation to the direct military advantage anticipated. So always it is the duty of the parties to an armed conflict to ensure that they do not cause disproportionate harm to the civilians' lives. The third principle is precaution. The attacking party must do everything feasible to avoid inflicting incidental harm as a result of its operations, and the party being attacked to the maximum extent feasible must take all necessary measures to protect the civilians under its control from the effects of the attacks carried out by the enemy. So both the parties, the attacking party and the party that is being attacked, have an obligation to ensure that civilians under their control are protected from the attacks of the enemy. And also, the state parties or the non-state actors cannot use civilians as human shields. That would be a breach of this fundamental principle of precaution. Next, we have humane treatment, or you can also refer to this as humanity. This requires all persons who have fallen into the power of the enemy to be entitled to humane treatment regardless of their status and previous functions or activities. This means even prisoners of war, wounded and sick soldiers, all of them are entitled to humane treatment without any discrimination. Finally, the principle of military necessity permits measures which are actually necessary to accomplish a legitimate military purpose. So in the case of armed conflicts, we know that the only legitimate military purpose is to weaken the military capacity of the other party to the conflict. So the law only allows what is absolutely necessary to achieve that military purpose or military objective, and nothing beyond that. So military necessity is also one of the fundamental principles followed in IHL. So that is the end of the introduction to international humanitarian law. There is another important topic that I will come up with in the next video. That is the difference between international humanitarian law and international human rights law. We will discuss about it in the next video. And for now, if you learned something from this video, consider subscribing and stay in touch. Thank you.